5 years old and sitting on a cinder block wall outside her home on a warm California evening in the summer of 2002, the kind of summer evening that smells like cut grass and sunscreen, the kind where kids stay out until the last slice of light disappears behind the rooftops, the kind that is so ordinary, so unremarkable, so perfectly safe feeling that no parent in that neighborhood had a single reason to worry. No reason at all. Her name was Samantha Runnion. She had dark hair and a gap-toothed smile, and she loved the color purple, and she had a best friend who lived 3 houses down, and on that particular Monday evening, July the 15th, 2002, the two of them were doing exactly what 5-year-olds and 6-year-olds do on a summer evening in a quiet California neighborhood. They were just being kids. Laughing. Talking. Sitting in the warmth of a day that hadn't quite ended yet. And then a car slowed down. And then a door opened. And then, in the space of seconds, in the time it takes to blink and breathe and look away, Samantha Runnion was gone. Not lost. Not wandered off. Not the kind of gone that resolves itself in 10 minutes when a child is found hiding behind a bush or in a neighbor's yard. The kind of gone that sends ice through a parent's veins. The kind of gone that changes everything, for a family, for a community, for an entire state's approach to child safety. Gone. Taken. Stolen in broad evening light from a street where everyone thought they were safe. And the only witness, the only human being on that street who saw exactly what happened, who saw the man's face, who heard the sound of the car door, who locked eyes with Samantha in those final seconds, was a 6-year-old girl clutching a stuffed animal. A little girl who would carry what she saw inside her for 3 years. A little girl who would eventually walk into a California courtroom, still clutching that stuffed animal, and point across the room and say in a voice barely above a whisper, "He throwed her into the car." When she was in the car, she just looked at me. I think she said, "Help." Or something. What she remembered would break a case wide open. What she couldn't have known, what none of them knew, was that the man she was pointing at had already faced the justice system once before. Had already looked a judge in the eye. Had already been given a chance that the system handed to him like a gift. And had walked away. Welcome to Coldcase Crimelab. I'm your host. And tonight we are going deep, deeper than we have ever gone on this channel, into one of the most haunting, most infuriating, and ultimately most important child abduction cases in California history. A case that demanded justice for one little girl. A case that eventually changed the laws of an entire nation. A case held together by the courage of a child witness, the relentless determination of a grieving mother who refused to sit down and be quiet, and DNA evidence so extraordinarily rare that forensic scientists placed the probability of it belonging to anyone other than their suspect at fewer than 1 in 1 trillion. 1 in 1 trillion. This is the story of Samantha Runnion. And before this is over, you will understand exactly why this case still matters, and why it always will. If this is your first time here at Coldcase Crimelab, welcome, you found us at the right moment, because this is exactly the kind of story we exist to tell. Hit that subscribe button right now and turn on your notifications, because we drop new cases every week and you do not want to miss what's coming. If you've been here before, you already know what we do. Leave a comment below, tell us you're here, tell us what brought you to this case, tell us what you already know about Samantha Runnion. We read every single one. Now, let's go back to Stanton, California. Let's go back to the summer of 2002. And let's try to understand how something this terrible could happen on a street this ordinary. To understand the Samantha Runnion case, you have to understand Stanton. Stanton, California sits in Orange County, that stretch of Southern California that most people associate with wealth, sunshine, theme parks, and a particular brand of suburban perfection that gets marketed in television shows and real estate listings. And parts of Orange County absolutely look like that. Parts of it are gleaming and manicured and exactly as advertised. Stanton is not those parts. Stanton in 2002 was a working-class city of roughly 38,000 people packed into just under 3 square miles, one of the smallest and most densely populated cities in Orange County. Apartments pressed up against small houses. Streets were narrow. Families were large and often multi-generational. People knew their neighbors, or at least they thought they did. There was a community there, real and genuine, the kind built over years of shared block parties and borrowed tools and kids running freely between houses. It was the kind of neighborhood where parents felt comfortable letting their children play outside in the evening. Where a 5-year-old and a 6-year-old sitting together on a cinder block wall at 6:30 at night felt completely, utterly, dangerously normal. And that sense of safety, that ordinary, earned, reasonable sense that this street was okay, that this neighborhood was okay, that nothing bad happened here, is exactly what made July the 15th, 2002 so catastrophic. Because safety is not a guarantee. It never is. It's an assumption. And assumptions, when they are wrong, cost everything. Samantha's family had moved to Stanton the previous year. Her mother, a woman we are going to talk about at length tonight, because she is one of the most important people in this entire story, had worked hard to give her daughter a stable life. Stable is a relative term. Life was not easy. Money was tight. But there was love in that house. Ferocious, protective, devoted love. And Samantha, bright-eyed, gap-toothed, purple-obsessed Samantha, seemed to thrive on it. She had started at a new school. She had made friends. She had, in particular, attached herself to the little girl 3 houses down, the 6-year-old who would become, without ever choosing it, the most important witness in the case that would follow. The 2 girls were inseparable the way only young children can be inseparable, completely, without agenda, without any of the social calculation that starts to creep into friendships as kids get older. They played together every day. They sat together on that cinder block wall nearly every evening. It was their spot. Their routine. Their ordinary, beloved, safe routine. On July the 15th, 2002, it was a Monday evening. School was out for the summer. The heat had been building all day the way California heat does, relentless, shimmering, cooking the asphalt until it releases that particular smell that anyone who grew up in Southern California knows like a childhood memory. By 6:30 in the evening the temperature had barely dropped. The girls were outside because being outside was better than being inside in the heat. They were sitting on the wall. Talking. Probably arguing about something trivial the way best friends do. Probably laughing. Probably completely unaware that anything in the world could go wrong. A vehicle came down the street. We know this because the 6-year-old saw it. And she remembered it. Children are, contrary to what many adults assume, often remarkably acute observers, precisely because they are not yet burdened by the adult tendency to filter out information that seems irrelevant. She saw the car. She saw it slow down. She saw the man. She saw him get out. She saw him move toward Samantha. She saw him grab her. She saw Samantha go into the car. She saw the door close. And she saw, in the last fraction of a second before the car pulled away, Samantha's face in the window. Looking back at her. And she thought, she believed, with the unflinching certainty of a 6-year-old processing something she had no framework to process, that Samantha said, "Help." Or something like that. Help. Or something. Those words. That image. The face of her best friend in a car window. A man she had never seen before and would never forget. These things lodged themselves somewhere deep inside that 6-year-old girl and they stayed there. For 3 years they stayed there. Through nightmares and questions and the slow, devastating understanding that her best friend was not coming back, that something had happened that day that children are not supposed to understand, the memory stayed. Intact. Clear. Waiting. The police were called within minutes. Samantha's mother was notified, and whatever she felt in that moment, whatever a mother feels when she is told that her 5-year-old daughter has been taken off a street by a stranger, is not something that can be adequately described in words. It is the kind of news that reorganizes a person at their most fundamental level. That replaces the version of you that existed before with someone entirely new. Someone who will spend every day that follows either searching or breaking apart or somehow, against every natural instinct, managing to do both at once. She chose to search. She would keep choosing to search. For years. But that is getting ahead of ourselves. In the immediate hours after Samantha's disappearance, police canvassed the neighborhood. They gathered what descriptions they could. The 6-year-old witness was interviewed, carefully, as gently as investigators could manage given the circumstances, and she gave them what she had. A man. A car. A direction. A face she could describe but not name. It was something. It was not enough. Not yet. The investigation in those first days had the quality that all such investigations have, urgent, frantic, hope-soaked. Every lead followed immediately. Every tip called in and assessed. The belief, always present in those first 72 hours, that if you move fast enough, if you are thorough enough, if you are lucky enough, you might still find the child alive. They did not find Samantha alive. The discovery of her remains, the details of which we will not dwell on unnecessarily tonight, out of respect for her family, came days later. What had been a desperate search for a missing child became something else. Became an investigation into a murder. Became the kind of case that sends a particular chill through an entire community because it confirms the worst fear that fear itself can generate, that a child can be taken from a public street in a residential neighborhood on a summer evening while her best friend is sitting right next to her, and that the person who takes her can disappear without a trace. The man in that car had disappeared without a trace. For now. Let us talk about what makes a child abduction case uniquely, devastatingly difficult to solve. When an adult is murdered, there is almost always, not always, but almost always, a prior relationship between the victim and the perpetrator. A spouse. A business partner. A neighbor with a grudge. An acquaintance from the wrong side of a deal that went bad. Adult murder victims almost always knew their killer in some capacity, and that prior relationship creates a trail. It creates a web of connections that investigators can map, people they can interview, motives they can identify. Stranger abductions, and the Samantha Runnion case was, from the beginning, characterized as a stranger abduction, don't work that way. There is no prior relationship. There is no obvious motive in the traditional investigative sense. There is no web of connections to map. There is only a victim and a perpetrator who, until the moment the crime was committed, had no documented connection to each other at all. What investigators have in these cases is evidence. Physical evidence. Witness accounts. And they have to hope that the evidence is sufficient, that the witnesses are reliable, and that somewhere in the physical world, in the fibers and the fingerprints and the biological material left behind at a scene, there is a signature that belongs to one specific person. In the Samantha Runnion case, the physical evidence collected in the days following the discovery of her remains was processed with the full resources of the Orange County Crime Lab. This was not a low-profile case. This was not a case that got pushed to the back of the queue. This was the kind of case, a child, an abduction, a murder, a community terrified, that commanded attention and resources and the full dedication of everyone involved. The processing took time. DNA processing always takes time. This is one of the great frustrations of crime investigations as they exist in reality rather than as they are depicted on television. In the real world, results do not come back in 45 minutes. Results come back in days, in weeks, sometimes in months. And when they do come back, they are only as useful as the database you have to compare them against. In 2002, the Combined DNA Index System, known as CODIS, was operational but not yet at the scale it would eventually reach. DNA matching was possible, but it required that the suspect's profile already be in the system. And the person who took Samantha Runnion, whoever he was not making himself easy to find. The case went without a named suspect. Weeks passed. Months passed. Samantha's mother never stopped. She called investigators regularly, sometimes more than once a day. She followed news reports. She maintained contact with victim advocacy groups. She kept Samantha's name in circulation through sheer force of will and relentless, exhausting, heartbreaking persistence. She was not going to let this become a cold case. She was not going to let her daughter's murder become a file in a cabinet somewhere, reviewed once a year and replaced on the shelf. She was going to get justice for Samantha if it took everything she had. It very nearly did take everything. The years that followed the summer of 2002 were not kind to Samantha's mother. Grief does not move in a straight line. Anyone who has experienced the loss of a child, or who has been close to someone who has, knows that the progression that therapists and well-meaning books describe, that neat sequence of stages from denial through bargaining through anger through acceptance, rarely maps onto the actual experience of mourning. The actual experience is more chaotic than that. More circular. A person can cycle through rage and numbness and desperate hope and crushing despair in the space of a single morning, and then get up and do it again the next day. For Samantha's mother, the grief was compounded by something that grief in ordinary circumstances does not always include, a quest. She was not only mourning. She was fighting. And fighting requires energy, and energy requires hope, and hope, when you are fighting for justice for a murdered child with no named suspect, is a resource that has to be rationed carefully. She rationed it. She had to. Because there were moments, and she has spoken about this in interviews over the years, with a candor that is both admirable and devastating, when the system felt like an obstacle rather than an ally. When phone calls went unreturned. When she sensed that investigators, buried under other cases, were losing the thread. When she feared that the momentum of those first frantic weeks had dissipated and that the case of her daughter's murder was settling into the particular stillness of the unsolved. She refused to let it settle. She learned the language of investigations. She educated herself on forensic procedures. She connected with organizations that advocated for the families of unsolved homicide victims. She made herself an informed, active, persistent presence in an investigation that might otherwise have faded, not because of indifference, but because of the simple, terrible arithmetic of a law enforcement system with finite resources and an infinite number of cases demanding attention. She was, in every meaningful sense, a co-investigator in her own daughter's murder case. Not in an official capacity. Not with a badge or access to evidence. But with information. With connections. With an absolute refusal to disengage. And all the while, 3 houses down, the 6-year-old who had watched Samantha disappear was growing up. She was 7 now. Then 8. Then 9. She started a new school year. She made new friends. She experienced, as all children do, the gradual accretion of new memories and new experiences that, for most children, slowly buries the painful moments of early childhood under years of growth and change. But she didn't bury what she saw that evening. She didn't forget his face. Investigators working cold cases, and make no mistake, by 2003, the Samantha Runnion case had the unofficial status of a case that was going cold, often describe the experience using a particular metaphor. They talk about cases as if they are fires. They say that a case that has been active and burning for weeks or months can cool down, can smolder, can seem to go dark. And then, sometimes without warning, something happens. A new piece of evidence. A database match. A witness who comes forward with new information. Or sometimes just a new investigator with fresh eyes who looks at old evidence and sees something that wasn't seen before. When the fire reignites, it reignites fast. In the Samantha Runnion case, the reignition came from 2 directions simultaneously. And it came, as it often does in cold cases, when investigators went back to what they had. The DNA evidence collected in 2002 had been processed. A profile had been developed. But the profile had not matched anyone in Cody's at the time of initial processing. This is not unusual, particularly in the early 2000s, when the database was still growing. The profile sat there. Waiting for its match. Like a key waiting for a lock. In the interim years, Cody's had grown. Significantly. More states were participating. More DNA samples were being uploaded from more cases. The net was getting wider. And periodically, investigators would run the Samantha Runnion profile against the updated database. They kept not getting a match. Until they did. The match, when it came, was not simple. DNA evidence in this case would ultimately be characterized, after full analysis, after peer review, after the battery of scrutiny that serious forensic evidence receives before it is presented in court, as placing the likelihood of the DNA belonging to anyone other than the identified suspect at fewer than 1 in 1 trillion. 1 followed by 12 zeros. The entire population of the Earth, multiplied by more than 140. The kind of number that, in any rational framework for evaluating probability, means one thing and one thing only: this was him. But a DNA match, however extraordinary, however statistically overwhelming, requires a name to attach to. And getting to that name, that is the story within the story of the Samantha Runnion case. Because the name, when investigators finally had it, came with a history. A history that made Samantha's mother's blood run cold. A history that made everyone who read it ask the same question: how was this man still free? His name is not something we are going to emphasize here, because names like his, names attached to crimes like his, have a way of becoming more prominent than they deserve, more remembered than the victims they victimized. We are going to refer to him, as we discuss this part of the story, as the suspect. Because that is what he was. A suspect. And then, eventually, a defendant. And then, finally, something else. But before he was any of those things in relation to Samantha Runnion, he had been something else in another case. In another jurisdiction. At another point in time. He had been accused of a crime involving a child. He had been brought before the justice system. He had faced what the system had to offer. And the system had let him go. The details of that prior case, the nature of the charges, the specific circumstances of how they were resolved, involve ongoing complexities of court record confidentiality that vary by jurisdiction and by the nature of the charges. What can be said, what has been reported in the coverage of this case, is that the pattern of behavior that led to Samantha's abduction and murder did not begin on July 15, 2002. That there was a before. That the before had been seen. That the before had been acted upon, to some degree, by some arm of the system. That the outcome of that prior action had not prevented what happened to Samantha. This is one of the most difficult and most important aspects of the Samantha Runnion case to sit with. It is easy, it is human, to want to assign blame clearly and simply when a child is murdered. The person who committed the act is to blame. That is true, and it is not in any way contested. But cases like Samantha's demand that we also ask harder questions. Questions about the systems and structures that are supposed to identify dangerous individuals and manage them in ways that protect potential future victims. Questions about the gaps between what those systems intend to accomplish and what they actually accomplish. Questions about what happens to the people those gaps swallow. Samantha Runnion fell through a gap. Her case, and the advocacy that followed, would eventually help close that gap. But that closing came too late for her. This is the tragedy that sits underneath the tragedy. When investigators identified the suspect, they moved carefully. This is always the tension in a high-profile case with strong forensic evidence, the desire to move quickly, to make an arrest, to deliver the news to a waiting family and a watching community, balanced against the absolute necessity of building a case that will hold together in court. DNA evidence of the quality they had in this case is extraordinarily powerful. But it still has to be presented correctly. It still has to be surrounded by corroborating evidence. It still has to withstand the challenge of defense attorneys whose job it is to find every possible weakness. And in this case, there was something else. Something that elevated the case from powerful to potentially overwhelming. There was the witness. The 6-year-old had grown up. It had been 3 years. She was now 9 years old. And investigators had to make a decision that required extraordinary sensitivity. Was she old enough to be interviewed formally? Did she still have the memory? Would what she had carried for 3 years still be usable? Would it be fair to ask her to revisit the worst moment of her childhood? The answers, it would turn out, were yes. 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 And yes, though that last yes came with qualifications and protections and careful handling that reflected everything the investigators, prosecutors, and advocates in this case had learned about working with child witnesses. She remembered. Of course she remembered. Some things don't go away just because time passes. Some images are burned in at a level deeper than ordinary memory. The face of the man. The car. Samantha's face in the window. The word, help, or something like it, formed by lips she could still see clearly in her mind. She remembered all of it. And when investigators, working now with the named suspect in their sights, showed her a properly constructed photographic lineup, she made her identification. Carefully. Without hesitation. With the kind of certainty that comes not from suggestion or guidance or pressure, but from genuine recognition. From a 9-year-old seeing, in a photograph, the face of a man she had last seen 3 years ago and had never managed to forget. She pointed to him. He throwed her into the car. 3 years later. 9 years old. And she pointed to him. The arrest was made. And what followed was the kind of legal process that is, in every true crime story, simultaneously the most important and the most difficult part to convey, because legal processes are slow and procedural and full of motions and hearings and continuances that stretch across months and years and that do not translate well into narrative. They do not have the urgent momentum of an investigation. They do not have the emotional immediacy of a victim's family waiting for news. But they matter. They matter enormously. Because it is in the legal process that the truth is tested. It is where the evidence is scrutinized and challenged and weighed. It is where the rules that govern what can be said and shown and argued are applied with painstaking care. It is where a system that has already failed Samantha Runnion once is given the opportunity to get something right. The prosecution built their case on multiple pillars. The forensic evidence, the DNA, 1 in 1 trillion, as close to certainty as science can deliver, was the foundation. But foundations need structures built upon them, and the prosecution constructed those structures carefully. There was the physical evidence from the scene. There was the investigative timeline that placed the suspect in proximity to Stanton on the evening in question. There was the record, complicated, partial, redacted in places, of his prior history. There was the work of detectives who had spent years on this case and who knew it at a level of granular detail that no defense team could easily unsettle. And there was the child witness. The decision to present her testimony was not made lightly. Child witnesses in court face enormous pressures and challenges. They face the disorienting formality of the courtroom. They face cross-examination. They face the physical presence of the person who, in this case, had committed an act of violence that their entire psyche had spent 3 years trying to process and survive. The potential for trauma, for re-traumatization, was real and serious and had to be weighed against the probative value of what she had to offer. The prosecutors weighed it. They consulted with child psychologists and victim advocates and legal experts in the specific area of child testimony. They prepared her as thoroughly and as gently as they could for what the courtroom would require of her. And then she walked in. 9 years old. Stuffed animal in her arms, the same kind of stuffed animal she'd been clutching the evening everything happened, the same kind of comfort object that had been with her through 3 years of nightmares and questions and growing up in the shadow of something no child should have to grow up in the shadow of. She sat in the witness stand. She answered the questions that were put to her. And when the moment came, when she was asked to identify, if she could see him in the courtroom, the man she had seen that evening on the street in Stanton, she raised her arm. She pointed. She said it again, in a voice barely above a whisper, in words that have since been quoted in legal textbooks and advocacy documents and news reports and in more than one piece of legislation. He throwed her into the car. When she was in the car, she just looked at me. I think she said, help. Or something. The courtroom was silent. Whatever sounds a courtroom makes, the shuffling, the background hum, the ambient noise of people gathered in a formal space, all of it stopped. A 9-year-old girl had just delivered the most powerful testimony in the room. If you are still watching at this point, and if this story is hitting you the way it is hitting the people in our community who have been following the Samantha Runnion case with us, drop a comment right now with the words, "I'm still here." We want to know who is truly following this story with us, who is feeling the weight of it, who understands why we do what we do at Coldcase Crimelab. Drop it in the comments. I'm still here. And keep watching, because what comes next, the verdict, the aftermath, and what Samantha's case ultimately changed for children across this country, is something you need to hear. The defense, as is their right and their obligation in any criminal proceeding, challenged everything. This is not a criticism of the defense. In the American legal system, in any functional adversarial legal system, the defense's job is precisely this: to challenge the prosecution's evidence, to find its weaknesses, to present the jury with every possible reason to doubt. The constitutional presumption of innocence that protects all defendants, including the most guilty, is not a technicality. It is a foundational principle. And it works, it functions as it is supposed to function, only when defense attorneys take that obligation seriously and perform it rigorously. In the Samantha Runnion case, the defense performed their obligation rigorously. They challenged the DNA evidence. They brought in their own experts to discuss statistical methodology and the potential for laboratory error. They questioned the chain of custody. They raised every legitimate challenge to the forensic science that the forensic science made available to be challenged. They challenged the child witness. They argued, carefully, because cross-examining a child witness about a traumatic event requires a particular kind of delicacy that attorneys in these cases have to learn, that the identification was the product of suggestive procedures. They raised questions about the reliability of childhood memory over time. They pointed to the 3-year gap between the event and the formal identification. These are legitimate arguments. They are arguments that defense attorneys in stranger abduction murder cases routinely make, and they are arguments that courts routinely require to be addressed, because that is how the system is supposed to work. Every claim tested. Every evidence challenged. Every alternative possibility raised. But the DNA was what it was. 1 in 1 trillion is not a number that responds well to alternative interpretation. The statistical methodology was sound. The laboratory procedures were properly documented. The chain of custody held. And the child witness, 9 years old, stuffed animal in her arms, voice barely above a whisper, had looked at a lineup constructed according to proper protocols, designed specifically to minimize the possibility of suggestion or contamination, and had pointed at the suspect without hesitation. Both pillars held. The jury deliberated. Jury deliberations in high-profile cases are always, for the families of victims, an almost unbearable waiting period. The verdict is out of everyone's hands. The evidence has been presented. The arguments have been made. The case now belongs to 12 people who have been sealed into a room together and asked to apply the standard of beyond a reasonable doubt to everything they have heard and seen over the course of the trial. Samantha's mother waited. 3 years of searching, of calling investigators, of educating herself, of refusing to let her daughter's case fade, of holding on to hope when hope felt like the hardest thing in the world to hold, and now she sat outside a courtroom and waited for 12 strangers to decide. She has described those hours. The alternating waves of confidence and terror. The way time moves differently when you are waiting for something enormous. The way you find yourself counting things, ceiling tiles, floor squares, the number of times people walk past, just to give your mind something to do that isn't catastrophizing. She waited. And then the jury came back. Guilty. On all counts. The verdict landed in that courtroom the way significant verdicts always do, with a weight and a sound and a quality of air that people present describe differently but that all convey the same thing, that something enormous has just happened, that the world has just sorted itself according to a new arrangement, that something that was pending is now settled. Samantha's mother heard the word. She has said, in interviews, that she did not feel what she expected to feel. That she had imagined, over 3 years of searching and advocating and hoping, that a guilty verdict would feel like release. Like the long-held breath finally let out. Like an ending. It did not feel like an ending. It felt like a different kind of grief. A grief that was sharper and cleaner than what she had been carrying, but no less heavy. Because a verdict, even the right verdict, even a verdict built on overwhelming evidence and delivered by a jury that clearly understood the gravity of what they had been asked to decide, does not bring a child back. It does not undo the evening of July the 15th, 2002. It does not give back the 5-year-old with the gap-toothed smile who loved purple and had a best friend 3 houses down. What it gives back is something else. Something that matters enormously, even though it is not the thing a mother most wants. It gives back her name. It gives back the truth of what happened to her. It says, on the public record, in the most formal language the law has available, this child was murdered, this is the person who murdered her, and this is what justice looks like when the system finally, gets it right. It gives back Samantha's name. The sentencing that followed was significant. The judge, in delivering the sentence, and we are going to be careful here about specific numerical details that could vary in reporting, made clear that the court understood both the severity of the crime and the aggravating factor of the prior history. The sentence was substantial. It was the kind of sentence that is intended to convey, in the clearest possible terms, that this type of crime against a child carries the maximum consequence that the law permits. It was not enough for Samantha's mother. It never could be enough. Not because the sentence was unjust, it was just, within the parameters of what the law permitted. But because adequate sentencing for the murder of a 5-year-old child is a concept that exists in law but cannot exist in a mother's heart. There is no number of years, no length of incarceration, that fills the space left by a daughter taken from a cinder block wall on a summer evening. What there could be, what there eventually was change. Real, structural, systemic change. The kind of change that meant that what happened to Samantha was less likely to happen to another child. The kind of change that gave meaning, not adequate meaning, never adequate meaning, but real meaning, to the terrible fact of her death. The Samantha Runnion case became a catalyst. In the months and years that followed the verdict, Samantha's mother, by now a figure of considerable public profile, known in victim advocacy circles and in the state legislature and in the community of families who have experienced similar losses, began redirecting the energy she had been pouring into the investigation into something new. She began advocating for legislative reform. Specifically, she focused on the gap that had allowed the suspect in her daughter's case to remain at large despite a prior history that, in a better designed system, should have flagged him as a danger to children. She focused on what happens, or what was happening at the time, to individuals who were charged with crimes involving children and whose cases were resolved in ways that left them free to reoffend. She was not alone in this advocacy. Other families had experienced similar losses. Other cases had followed similar patterns, a prior history, a system gap, a tragic outcome. The community of advocates working on these issues was larger than most people realized, and it was populated by people who had the same combination of personal devastation and specific, hard-won knowledge that Samantha's mother brought to the table. Together, they made noise. They made a lot of noise. They testified before state legislative committees. They provided data, carefully compiled, scrupulously documented data, on the outcomes of cases involving defendants with prior histories of charges related to crimes against children. They argued for more rigorous tracking systems, better interagency communication, stronger requirements for the sharing of relevant prior history information between jurisdictions. They argued, in particular, for what would come to be known, through various iterations of legislation in California and eventually at the federal level, as reforms directly inspired by cases like Samantha's. Reforms that tightened the net. That made it harder for individuals with documented histories of danger to children to disappear back into communities without appropriate monitoring and response. Samantha's mother gave her daughter's case a second purpose. A terrible, extraordinary second purpose. She turned the story of Samantha's murder, a story that could have existed only as a tragedy, into the foundation of a movement that has, by any measurable standard, saved lives. That is not a small thing. That is, in fact, one of the most remarkable and important things that a person can do in response to the worst experience that life can deliver. Let us talk about the child witness for a moment, because she deserves more than a role in the legal narrative. She is, by now, not a child. The years that have passed since the summer of 2002 have transformed the 6-year-old on the cinder block wall into an adult who has had to carry, for the entirety of her conscious life, the memory of that evening. The stuffed animal she clutched in the courtroom is presumably packed away somewhere, in a box, in a closet, in the particular category of childhood objects that we do not use anymore but cannot bring ourselves to discard because they carry too much weight. What she carries, more significantly, is the knowledge of what she did. At 9 years old, she sat in a formal courtroom, one of the most intimidating environments that adult human beings navigate, to say nothing of children, and she told the truth. She pointed at the man. She said what she saw. She gave Samantha's case its most human, most undeniable, most unforgettable moment. Legal scholars have written about this case specifically in the context of child witness testimony. It has been used as an example, a case study, really, in discussions of how to properly prepare child witnesses, how to structure courtroom procedures to accommodate the specific needs and vulnerabilities of young witnesses, how to ensure that the drive to protect children from trauma in the legal process does not inadvertently silence the witnesses who are sometimes best positioned to speak. Her testimony changed conversations. Not just in the Samantha Runnion case. In the field. In the practice of prosecutors and victim advocates and child psychologists working at the intersection of criminal law and childhood trauma. She was 9 years old and she changed conversations. There is something about that, something humbling and heartbreaking and genuinely extraordinary, that this case gives us to sit with. The DNA evidence in the Samantha Runnion case also deserves its own examination, because it represents something remarkable about the state of forensic science in the early 2000s and about the trajectory that forensic science has followed in the years since. When investigators first processed the evidence collected in 2002, the DNA they extracted was sufficient to develop a profile. But the profile found no match in Cody's at the time. This is, as we discussed earlier, a common experience in investigations from that era. The database was growing but not yet comprehensive. The suspect's DNA was not in the system. The profile waited. DNA evidence does not degrade the way some types of physical evidence degrade. It does not become less accurate because it has been sitting in a database for years. It does not forget. In a sense, a very precise, very scientific sense, DNA evidence is the most patient kind of witness there is. It will wait as long as it needs to wait. And when the match finally comes, it arrives with the same precision it would have had on day one. When the suspect's DNA finally entered the system, through mechanisms that we are going to be deliberately general about, because the specific circumstances of how a suspect's DNA enters Cody's can involve sensitive legal and investigative details, the comparison to the Samantha Runnion profile was essentially automatic. The system flags matches. Investigators are notified. And suddenly, a profile that has been waiting in the database for years is connected to a name. 1 in 1 trillion. When forensic analysts discussed this probability with investigators, the conversation reportedly included an attempt to contextualize what that number actually means. 1 in 1 trillion exceeds the population of the entire Earth by a factor of more than 100. It exceeds the estimated number of humans who have ever lived in all of human history. It exceeds every meaningful population-based comparison that can be made. In practical terms, what it means is this: if you took every person who has ever existed, and every person who currently exists, and every person who will exist for generations to come, and you tested all of their DNA against the profile found in the Samantha Runnion case, the expected number of matches, the expected number, would be a fraction of a single person. It was him. The forensic science, applied with rigor and presented with appropriate care, said so as clearly as science is capable of saying anything. The intersection of science and justice is always interesting. It is interesting because science operates according to a logic of probability and evidence that is different in important ways from the logic of the law. Science is never 100% certain, it cannot be, by definition, because the scientific method is built on the acknowledgement that knowledge is always provisional, always subject to revision in the face of new evidence. Science deals in probabilities and confidence intervals and error rates and the honest acknowledgement of what is known and what is not. The law, on the other hand, deals in verdicts. In binary outcomes, guilty or not guilty, that require 12 people to agree on one answer. The law uses the concept of beyond a reasonable doubt as its operative standard, and while that standard has a specific legal meaning, its application in the jury room is ultimately a human judgment, not a calculation. The challenge of forensic science in the courtroom, the challenge that has driven decades of research and reform in how DNA and other scientific evidence is presented to juries, is the challenge of translating scientific probability into the language of legal certainty in a way that is honest, accurate, and comprehensible to 12 people who may have no scientific training. The prosecution in the Samantha Runnion case handled this translation carefully. They presented the DNA evidence in a way that was clear without being oversimplified, that acknowledged the theoretical possibility of error while making clear that the probability of that error was, in any practical sense, 0. They used the 1 in 1 trillion figure not as a magical number but as a context, a way of helping the jury understand, in human terms, what a profile match at that level of specificity actually means. The jury understood. This is, in itself, a kind of victory, not for the prosecution specifically, but for the field. For the advocates and researchers and legal reformers who have spent years working to ensure that the extraordinary power of DNA evidence is communicated to juries in a way that serves justice rather than confusing it. There is a broader story embedded in the Samantha Runnion case. A story that runs underneath the specific facts of this specific crime, connecting it to a pattern that criminologists and legal scholars and victim advocates have documented extensively, the pattern of the recidivist offender. The person who commits a crime, encounters the justice system, is processed in some fashion, and then, because the system's response was insufficient, or because the system's information sharing was inadequate, or because of any number of other structural failures, goes on to offend again. This pattern is not rare. It is disturbingly common. And it is, in the specific context of crimes against children, one of the most painful and most important patterns that anyone working in child protection can identify. Research on recidivism among individuals who commit violent crimes against children is both extensive and sobering. The data shows, with considerable consistency, that individuals who commit certain categories of violent crime against children are at statistically elevated risk of reoffending. The data also shows, and this is the part that connects most directly to cases like Samantha's, that the intervals between offenses can vary enormously. Some individuals reoffend quickly. Others have intervals of years. The length of the interval does not predict the certainty of reoffense, but it does create a false impression, for communities, for oversight systems, for the individuals themselves sometimes, that the danger has passed. The danger does not always pass. In Samantha's case, the danger hadn't passed. Whatever interval existed between the prior history and the evening of July 15, 2002, the danger was still there. Still active. Still looking for an opportunity. And the systems that should have been able to identify and respond to that danger had not done so adequately. The advocacy that Samantha's mother channeled into legislative reform was targeted precisely at this failure. At the mechanisms, or lack of mechanisms, that allowed someone with a documented history of danger to children to remain effectively invisible to the community-level protective systems that might have kept children like Samantha safer. The reforms that followed were imperfect, as all legislative reforms are imperfect. They were the product of negotiation and compromise and the specific political moment in which they were passed. But they were real. They made changes to how certain categories of prior history were tracked and communicated. They made changes to the requirements for notification and monitoring of individuals with relevant prior histories. They contributed to a national conversation about child safety that has continued to evolve in the years since. They were not enough, advocates will tell you they were not enough, and they are right. The work is ongoing. The gaps that exist today in child protection systems are different from the gaps that existed in 2002, but they exist. They will always exist to some degree, because systems built by humans are always imperfect. But they are smaller. Because of Samantha. Because of her mother. Because of a 9-year-old girl who clutched a stuffed animal and pointed across a courtroom and said, "He throwed her into the car," with a clarity and a courage that no adult in that room could have improved upon. Cold cases, genuine cold cases, the kind that sit unsolved for years and then finally break, have a particular quality to them when they resolve. There is something almost alchemical about it. The same evidence that was insufficient for years becomes, suddenly, sufficient. Not because the evidence changed, it did not, but because the world around it changed. A database grew larger. A technology improved. A witness was old enough to testify. A suspect's DNA entered a system it hadn't been in before. The case of Samantha Runnion is not, by the strictest definition, a cold case. It was active throughout, investigators maintained it, resources were applied to it, leads were followed. But it shares with cold cases that quality of long patience eventually rewarded. The DNA profile that waited in the database. The witness who waited inside her own memory. The mother who waited and searched and refused to stop. They all waited. For 3 years. And then the pieces that needed to come together came together. This is, in some ways, the most important lesson of cold case investigation, that the resolution of an unsolved case is rarely the product of a single breakthrough. It is the product of persistence. Of maintaining the evidence. Of keeping the case in the active consciousness of investigators and advocates. Of not letting the file settle too comfortably on the shelf. Samantha's mother did not let the file settle. That persistence mattered. It kept the case alive in ways that are difficult to quantify but that investigators who worked on it have acknowledged. When you know that a victim's family is watching, when you know that someone is counting on you to keep trying, it is harder to let a case drift. It is harder to let a lead go unexamined for longer than it should. It is harder to accept that you might never solve it. The pressure that grieving families exert on unsolved investigations is not always comfortable for investigators. It can create tension. It can feel, in moments, like oversight or criticism. But it is also, often, what keeps cases alive. What keeps detectives going back to evidence they have examined before, looking for something new. What keeps the possibility of resolution open. Samantha's mother knew this. She applied that pressure deliberately and strategically and without apology. And it helped. We want to spend some time now on the geography of this case. Not just the physical geography, Stanton, California, the street, the house, the cinder block wall, but the emotional and social geography that shapes a community after something like this happens. Communities react to violent crimes against children in ways that are, in many respects, predictable. There is an immediate outpouring of grief and shock and communal pain. There are vigils. There are flowers. There are gatherings where people who barely know each other stand together in the dark because the alternative, standing alone with this, is unthinkable. And then, eventually, life goes on. This is not callousness. It is biology. Human beings are built to continue. The brain cannot sustain acute grief indefinitely. It modulates. It adapts. It finds ways to carry the weight of terrible things that allow the rest of life to proceed. This is how communities survive. But the survival is not clean. It leaves residue. It leaves in families and neighbors and the children who grew up on the street where Samantha disappeared a particular kind of awareness, a knowledge of the world that they did not have before. An understanding that ordinary summer evenings can turn. That cinder block walls are not safe. That a car can slow down and everything can change. This knowledge does not make people paranoid, exactly. But it recalibrates them. It changes the specific calculations they make when they are deciding whether it is okay for a child to sit outside. Whether it is okay for the kids to play on that particular street. Whether the community is as safe as it felt before. In Stanton, in the months and years after Samantha's disappearance, parents kept their children closer. This is documented not just in the anecdotal accounts of residents but in the observable patterns of neighborhood life that locals have described: fewer kids outside unsupervised. More parents visible on front steps and in yards. A general tightening of the radius within which children were permitted to move freely. This is the invisible cost of violent crime against children in communities. The freedom that children are supposed to have, the particular, precious freedom of unsupervised outdoor play that represents something essential about childhood, contracts. The world that was supposed to be safe shrinks a little. And the children who grow up in the aftermath grow up with a slightly smaller world than they should have had. Samantha's case took that freedom from a neighborhood. Her mother's advocacy tried, in a broader sense, to give some of it back, not to Stanton specifically, but to communities like it. To create a world where parents had slightly more reason to feel that the systems designed to protect their children were functioning adequately. To make the risks, if not smaller, then at least better understood and better managed. Let us return, for a moment, to the courtroom. Because there is something about the image that this case gives us: a 9-year-old girl, stuffed animal, voice barely above a whisper, finger pointed across the room, that deserves to be held for a little longer. Child testimony in criminal courts is one of the most carefully studied and most actively debated areas of legal practice and psychology. The history of how courts have treated child witnesses is not a comfortable one. For much of legal history, children were considered inherently unreliable witnesses, presumed to be too suggestible, too confused about the boundary between reality and fantasy, too easily led by adult questioners to be trusted as sources of accurate testimony. This presumption was wrong in important ways. It was wrong in the way that many presumptions are wrong. It contained a kernel of legitimate concern. Children are more susceptible to certain kinds of suggestion than adults. Children's memory systems work differently in ways that affect how they encode and retrieve information, but stretched that concern far beyond what the evidence actually supported. The research conducted from the 1970s onward, particularly the work that exploded in the 1980s and 90s in response to high-profile child abuse cases that forced courts and psychologists to grapple seriously with the question of how to assess child testimony, established something important: children can be accurate witnesses. Particularly for significant, salient events, events that were frightening, that were unusual, that engaged the child's full emotional attention, children's memories can be remarkably durable and precise. The key variables are not the child's age per se, but the nature of the event and the procedures used to elicit the testimony. A child who witnessed something frightening and significant, interviewed with proper protocols designed to minimize suggestion and leading questions, can provide testimony that is accurate and reliable and valuable. The 6-year-old on the cinder block wall, who became the 9-year-old in the courtroom, had witnessed something frightening and significant. She had been processing it, in the way that children process traumatic events, for 3 years. Her memory of the core event, the man, the car, the face, was what researchers would describe as central detail memory. The kind of memory that tends to survive the passage of time better than peripheral detail memory because it was so emotionally encoded. When the proper protocols were used to elicit her testimony, they found what was there: a clear, consistent, accurate memory of what she had seen. She gave Samantha justice. There is one more aspect of this case that we need to address. One more layer that makes it not just a tragedy and not just a crime story and not just a case study in DNA evidence and child witness testimony, but something more complicated and more important. This case, the Samantha Runnion case, from July of 2002 to its resolution, is, at its core, a story about what society owes to children. It is a story about the obligation that exists in any community to protect its most vulnerable members. Children cannot protect themselves from adult predators. They are, by definition, at a power disadvantage so total that the very concept of self-protection becomes almost meaningless when applied to a 5-year-old on a cinder block wall. The systems of protection that society constructs, neighborhood watchfulness, law enforcement, the courts, the legislative frameworks that govern how dangerous individuals are tracked and managed, exist precisely because children cannot protect themselves. When those systems fail, it is a societal failure. Not just the failure of any individual actor within the system, though individual actors can certainly contribute to systemic failures, but a collective failure. A failure that belongs to all of us in the sense that all of us are responsible for the systems we maintain and the gaps we allow to persist. Samantha Runnion's murder was a collective failure. Not in the sense that everyone who lived near her or worked in law enforcement or served in the legislature bears personal moral responsibility for what happened to her. But in the sense that the gap through which the person who murdered her fell was a gap that the system had created and had not adequately addressed. Her mother's advocacy was, in this sense, an act of holding the collective accountable. Of saying, this gap existed. It existed before Samantha. It existed in ways that could have been identified and addressed. It was not. My daughter is dead as a consequence. And we are going to fix it. That accountability, that refusal to let the system off the hook for its own failures, is one of the most important things that victims' families can do. Not all families have the capacity to do it. Not all families have the resources or the platform or the particular combination of devastation and determination that allows them to redirect grief into advocacy. Samantha's mother did. And the children who have been safer because of the reforms her advocacy helped produce, children who will never know her name, who will never know the name Samantha Runnion, who will simply live their lives unbothered on summer evenings because the system was a little tighter and a little better than it was before, those children are her daughter's second legacy. The first is the truth about what happened. The second is the change that came after. Both matter. Cold case investigations, the kind we focus on here at Coldcase Crimelab, are always, at some level, a reckoning with the relationship between time and justice. Time is supposed to be justice's enemy. The longer a case goes unsolved, the more evidence degrades, the more memories fade, the more the trail goes cold. This is the conventional wisdom about unsolved cases, and it is true to a significant degree. But time is also, in some ways, justice's ally. Databases grow. Technologies improve. Witnesses mature into adults who can testify in ways that children cannot. New investigators with fresh perspectives look at old evidence. Prior offenders whose DNA was not in Cody's in 2002 find themselves in the system for reasons unrelated to the original case. The Samantha Runnion case demonstrated both sides of this dynamic. Time was the enemy in the sense that Samantha's family spent 3 years waiting. 3 years of grief and searching and advocacy. 3 years of a case that the suspect apparently believed he had escaped. But time was the ally in the sense that the database grew. That the child witness became old enough to testify in court. That the evidence was maintained and processed and waited for its match. 3 years is a long time for a family. It is a blink of an eye for a DNA database. This is one of the remarkable things about living in the age of genetic forensics, the evidence does not forget. It does not get tired or discouraged or overwhelmed by other cases. It sits in the database and it waits, with perfect, inhuman patience, for the match that will unlock it. And when the match comes, justice comes with it. We want to close this part of the story, before we reach the final chapter, by talking about Samantha herself. Not the victim. Not the case. The child. She was 5 years old. She had been alive for 5 years when the summer of 2002 arrived. 5 years of being loved by her mother. 5 years of making friends and losing friends and making new ones. 5 years of learning things, how to read, how to ride a bike, how to negotiate with a best friend over which game to play on a summer evening. 5 years of being a person in the world. She loved the color purple. This is something her mother has mentioned repeatedly in public remarks, in interviews, in the advocacy work that has followed. It is the kind of specific, vivid detail, the color purple, that cuts through the abstraction of crime reporting and legal proceedings and advocacy work and reminds us that we are talking about a child. A specific child, with specific preferences and specific loves and a specific way of being in the world that was entirely her own. She had a gap-toothed smile. She had a best friend who lived 3 houses down. She had a mother who loved her with a ferocity that, even in grief, even across years of loss, is visible in every account that mother has given of her daughter. She was 5 years old and she should have grown up. She should have been in 3rd grade and then 6th grade and then high school. She should have developed opinions about music and movies and the kind of thing that matters enormously to adolescents and not at all to anyone else. She should have had heartbreaks and triumphs and ordinary boring Tuesday afternoons that she would not remember because nothing of significance happened. She should have had a life. She didn't. She had 5 years and a mother who loved her and a best friend and a stuffed animal and a cinder block wall on a summer evening that turned into the last evening she would ever have. And she had a case, her case, that changed the laws for other children. That made the world, in some small measurable ways, safer for other 5-year-olds sitting on cinder block walls on summer evenings. That is her legacy. Samantha Runnion. 5 years old. Murdered in the summer of 2002 in Stanton, California. Whose case was built on a DNA match of 1 in 1 trillion and the testimony of a 9-year-old girl who never forgot his face. Whose mother never stopped fighting. And whose name we say, tonight, so that she is not forgotten. Let us talk about what happened after the verdict in broader terms, because the story does not end at the sentencing, and it does not end with legislative reform. It continues, in the lives of everyone this case touched, in ways that ripple outward and outward until they are hard to trace but are real nonetheless. The 6-year-old who witnessed the abduction, now an adult, has, according to accounts that have emerged over the years, carried the experience of testifying in complex ways. She carried it as a child. She carried it as a teenager. She carries it now. This is not something that resolves cleanly or completely. She was 9 years old when she sat in that courtroom. She is, today, an adult who was shaped indelibly by having been 9 years old in that courtroom. What she gave, what she contributed to justice for Samantha, was enormous. What it cost her, in the private accounting of her own life and her own psychology, is something only she knows. We hope it is something she has been able to carry with the support of people who understood what she gave and what it required of her. We hope the adults in her life, then and since, have honored what she did without burdening her with more responsibility for it than any child should have to bear. She did something extraordinary. She was 9 years old and she did something extraordinary. And the hope is that, wherever she is now, she knows that. Samantha's mother, in the years since the verdict, has not stopped. This is worth emphasizing because it is easy, in the narrative arc of crime stories, to treat the verdict as the ending. As the point where the narrative closes and everyone moves into whatever comes next. But for victims' families, the verdict is not an ending. It is a transition. From one phase of grief to another. From active searching to active advocacy. From the question, who did this, to the question, what do we do now? For Samantha's mother, what do we do now, has meant continuing to speak. Continuing to advocate. Continuing to show up in rooms where policy is being made and to bring with her the specific, undeniable, heartbreaking weight of what it means to lose a child to a crime that the system had the chance to prevent. She has spoken to legislative committees. She has spoken at conferences for victim advocates. She has spoken to journalists and documentary filmmakers. She has done this not because it is easy, it is, by her own account, never easy, but because silence would mean that Samantha's death had no second meaning. That it was only a tragedy, without being also a catalyst. She has made it a catalyst. And in doing so, she has honored her daughter in the way that is available to her. The way that does not bring Samantha back, nothing does that, but that says, to the world, my daughter's life mattered. My daughter's death will mean something beyond its own horror. My daughter will be remembered, and the memory of her will make things better for other children. This is what love looks like when it has nowhere left to go but forward. The Samantha Runnion case has also been significant in the context of ongoing debates about child safety legislation at both the state and federal level. The specific gap that allowed the suspect in this case to remain in the community without adequate oversight, the gap between a prior history and a current monitoring system, was not unique to California. Similar gaps existed, and in various forms continue to exist, in jurisdictions across the country. The patchwork nature of American law, with its combination of federal frameworks and state-specific implementations, creates a landscape in which information about dangerous individuals does not always travel effectively across jurisdictional lines. Advocates in the child safety space have been working to address this for decades. The work is ongoing. The Samantha Runnion case is one of many cases that have been invoked in these debates, one of many cases where a clearer information trail, a more effective monitoring system, a better designed mechanism for tracking individuals with relevant prior histories, might have changed an outcome. Might have. These are conditional statements. They have to be conditional statements, because we cannot know with certainty what would have happened in a world with different systems. We can only look at the evidence, draw reasonable inferences, and work toward a future where the number of children lost to preventable crimes is smaller than it is today. That is the work. It is unglamorous work. It is legislative and bureaucratic and technical, and it happens largely out of public view. But it is the work that changes outcomes. That makes the difference between a child who comes home from a summer evening on a cinder block wall and one who does not. The forensic science community, too, has taken lessons from the Samantha Runnion case. The way DNA evidence was handled, presented, and ultimately received by the jury in this case has been studied by forensic science educators and legal practitioners as an example of effective expert witness testimony. The way the 1 in 1 trillion probability was communicated to a jury, clearly, accessibly, without sacrificing scientific accuracy, has been cited in discussions about best practices for forensic science communication in court. The DNA itself has become a kind of reference point. Not because the science it represents was unique, DNA matching at this level of specificity is not uncommon when sufficient sample quality is available and the database is adequate, but because the way the case used the science was exemplary. Because it demonstrated what is possible when forensic evidence is maintained properly, processed rigorously, and presented with both scientific integrity and communicative clarity. There are cases that advance the field. Not because of the crime itself, crimes do not advance fields, they destroy lives, but because of how the investigation and prosecution handled the evidence and the process. The Samantha Runnion case is one of those cases. It is studied. It is cited. It is part of the accumulated body of experience from which future investigators and prosecutors and forensic scientists learn. That, too, is a legacy. Impersonal, technical, removed from the human tragedy at its heart. But real. What does justice feel like? This is a question that everyone who has lost someone to violent crime, or who has worked in victim advocacy, or who has covered these cases as journalists or as content creators eventually has to wrestle with. Because the word justice is used so readily in the language of crime and law, we say we are seeking justice, we say justice was done, we say justice was served, that it can become abstract. It can become a word that we use without quite knowing what we mean. What does justice actually feel like, in the body, in the moment when a verdict is delivered? Samantha's mother has tried to describe this. She has said that it was not what she expected. That there was relief, something like relief, but that it was mixed with so much else. With grief that was suddenly free to express itself in ways that the active searching had suppressed. With anger at the years it had taken. With a kind of sorrow for the 9-year-old who had had to testify. With, underneath everything, the persistent, unanswerable knowledge that none of it brought Samantha back. Justice, she has said in various iterations, is not a restoration. It is an acknowledgement. It is the world, the formal, legal, official world, saying, we see what happened here. We know who did this. And we are naming it and responding to it with all the seriousness it deserves. That acknowledgement matters. It matters enormously. But it is not the same as restoration. The gap between what justice can do and what grief requires is one of the most painful spaces in human experience, and it is a space that families like Samantha's learn to inhabit, not comfortably, not without suffering, but permanently. They learn to live there. And they find ways, as Samantha's mother found ways, to make that living mean something. The Samantha Runnion case sits in a long lineage of cases involving the abduction and murder of young children that have, over the decades, shaped American law and public consciousness around child safety. From cases in the 1980s that prompted the establishment of the National Center for Missing and Exploited Children, to cases in the 90s and 2000s that drove the development of various legislative frameworks bearing the names of murdered children, the history of child safety law in America is written, in part, in the names of children who should never have needed to have laws named after them. Samantha's case is part of that history. It did not generate legislation bearing her name. The reforms it inspired were part of broader legislative packages with names that reflected political processes rather than individual victims. But her case is part of the evidentiary foundation on which those reforms were built. Her mother's testimony is part of the record. Her story is part of the case that was made. Her name belongs in that lineage. Not on a law, but in the story of how the laws came to be. In the room where advocates stood up and said, again and again, with whatever evidence and whatever grief and whatever determination they could muster, this cannot keep happening. We know why it happens. We know how to make it happen less often. Let us do that. Samantha Runnion belongs in that room. There is a particular cruelty in cases where the victim is very young that is different in quality from other kinds of criminal cruelty. It has to do with futures. With the specific fact that a young child who is murdered did not simply lose their life, they lost every version of their life that might have been. Every experience they might have had. Every relationship they might have formed. Every morning they might have woken up to. The loss is not bounded by what existed. It is unbounded, it encompasses everything that would have been. This is one reason why cases involving young victims hit us, as audiences and as communities, with such particular force. We respond not just to the horror of what happened but to the vast, incalculable weight of everything that did not happen. Of a life that was supposed to be. Samantha was 5. She had, if we use actuarial life expectancy as a rough measure, somewhere in the vicinity of 70 to 80 years of life ahead of her on the evening of July 15, 2002. 70 to 80 years of mornings and decisions and relationships and experiences. 70 to 80 years of being a person in the world. All of that, all 70 to 80 years of it, was taken from her in the time it takes to open a car door. The person who took it spent time in the justice system and was returned to freedom before July 15, 2002. And then, on that evening, in the time it takes to open a car door, everything that Samantha would ever have been was gone. The injustice of that, not just the crime, but the prior failure that allowed the crime to occur, is something that no verdict fully resolves. It is something that the system has to carry. Something that the advocacy community has to carry. Something that we carry when we tell stories like this one, because telling these stories is how we keep the weight of them in the public consciousness, where it belongs. Where it might continue to do some good. We have been talking tonight about a case that is, in its specifics, the story of one child and one family in one city in California in the summer of 2002. But the reason it matters beyond those specifics, the reason we bring it to you here at Coldcase Crimelab, the reason it deserves the hours of examination we have given it tonight, is that it is not, really, only about one child and one family in one city. It is about all the children who are, at this moment, sitting on cinder block walls on summer evenings in neighborhoods across this country. About all the parents who are letting them do that because it feels safe. About all the systems, the databases and the monitoring frameworks and the legislative protections and the information sharing agreements, that are supposed to make that feeling of safety something closer to a reality. It is about the gap between the safety we assume and the safety we actually have. And about the work, endless, unglamorous, legislative and forensic and advocacy work, that closes that gap, one small increment at a time. The Samantha Runnion case closed some of those gaps. Not enough. Not close to enough. The work is not done. But some. And some, when you are talking about the lives of children, is not nothing. Some means children who will go home from summer evenings the way they were supposed to. Some means mothers who will not have to live what Samantha's mother lived. Some means the terrible, countable number, of children who are taken from streets like the one in Stanton is a little smaller than it would have been. Some. It is the only word available. And it has to be enough to keep working toward. Before we close tonight, we want to revisit one final image from this case. A 9-year-old girl. Stuffed animal in her arms. Voice barely above a whisper. Arm raised. Finger pointing across the courtroom. He throwed her into the car. When she was in the car, she just looked at me. I think she said, "Help." Or something. That image, that specific, particular, unforgettable image, is the center of the Samantha Runnion case in a way that no piece of forensic evidence, however extraordinary, can quite match. Not because the testimony was more legally significant than the DNA. It wasn't. The 1 in 1 trillion DNA profile was the foundation of the case. The forensic science was what made the prosecution possible. But the image of that child, in that courtroom, saying those words, that is what makes the case human. What makes it real in the way that no laboratory report can make it real. What takes it out of the realm of case files and statistics and legal proceedings and places it firmly, unmistakably, in the realm of human beings and what they owe each other. A 6-year-old had watched her best friend disappear. A 9-year-old had walked into a courtroom and told the truth. She did it without flinching. Without the sophistication or the protection that adults bring to the performance of courage, because children don't perform courage the way adults do, they just do what needs to be done in the only way they know how to do it, which is directly and simply and without the complications that self-consciousness introduces. She did what needed to be done. She said what she saw. And justice, when it came in part because a child was brave enough to remember and honest enough to say it. Samantha Runnion. 5 years old. Stanton, California. July the 15th, 2002. A gap-toothed smile and a love of purple and a best friend 3 houses down and a mother who would spend 3 years searching and decades advocating and who has never stopped saying her daughter's name. The system failed her once. The courage of a child, the patience of science, the determination of a mother, and the eventual proper functioning of the system gave her justice. It is not enough. It never is. But it is something. And we say her name tonight so that she is not forgotten. Because she deserves to be remembered. Because every child who is taken from a summer evening deserves to be remembered. Because memory, collective memory, public memory, the kind that lives in conversations and stories and the occasional Tuesday night when someone sits down to make sure a child's name is said out loud, is the only immortality we can actually give. This is Coldcase Crimelab. And this has been the story of Samantha Runnion. Say her name. If this case has stayed with you, if you've been sitting with what we've shared tonight and you find yourself thinking about Samantha, about her mother, about the little girl who never forgot what she saw, then please take a moment right now to like this video, leave a comment below, and subscribe to Coldcase Crimelab if you haven't already. We are here every week, telling the stories that demand to be told, giving voice to the victims who cannot speak for themselves, and honoring the families who refuse to stop fighting. Hit that like button. Subscribe. Turn on your notifications. And leave a comment telling us what this case made you feel, what you will take away from tonight, or simply the name, Samantha, so that she is remembered by everyone in this community, together. We will be back soon. Until then, stay safe, hold your people close, and remember, cold cases don't close themselves. Someone has to keep asking the questions. We will keep asking. Good night. Coldcase Crimelab, because cold cases don't close themselves. There is something about the month of July in Southern California that stays in the memory long after everything else has blurred. July in Orange County has a particular quality, a heaviness in the air that is not quite humidity the way the East Coast knows humidity, but something close. A weight. The kind of heat that makes the pavement shimmer and turns the horizon above the rooftops into a slow, liquid wavering. The kind of heat that makes ice cream melt faster than a child can eat it, that makes car seats burn through clothing, that makes the inside of a parked vehicle dangerous within minutes. By July the 15th, 2002, that heat had been building for weeks. The summer of 2002 was, by most meteorological accounts, a hot one across Southern California, the kind of summer that climate scientists look back on now with a particular kind of recognition, understanding it as part of a pattern that was already asserting itself even then. But in the summer of 2002, most people in Stanton were simply experiencing it as heat. As something to be managed with fans and open windows and evenings spent outside once the sun had dropped low enough to take the edge off. That was what the children on the street were doing that evening. Taking the edge off. Being outside because outside, by 6:30, was better than inside. The specific street where Samantha Runnion and her best friend sat on the cinder block wall has been described, in various accounts of this case, as typical of working-class Stanton. Apartment buildings on one side. Small single-family homes on the other. Cars parked tightly along both curbs, the kind of neighborhood where parking is always at a premium because the density of families exceeds the density of driveways. Trees in some yards, the kind of middle-sized trees that take decades to grow and that provide real shade, a precious thing in a California summer. The street had the quality of being known. Of being the kind of street where you recognize the cars that belong and notice the ones that don't. Where you know which dog barks at what hour and which neighbor leaves for work early and which one tends to be on their front step in the evening. This knowledge, this communal, accumulated, unspoken knowledge of the ordinary rhythms of a place, is what creates the feeling of safety in a neighborhood. Not formal security measures. Not locked gates or cameras. But the organic watchfulness of people who know each other's patterns and are therefore positioned to notice when something is off. On July the 15th, that watchfulness was not enough. Whether it was because the street was briefly empty of adults in that particular window of time, or because the car and the man moved with a speed and purposefulness that left no window for intervention, or because the event unfolded so quickly that by the time anyone might have processed what they were seeing it was already over, we cannot know with certainty. What we know is that a man came down that street in a vehicle, and he stopped, and he took a child, and he left. And only one person on that street, in that moment, was in a position to see it fully. A 6-year-old girl. With a stuffed animal. Who remembered everything. The experience of being a witness to a crime, particularly a violent crime, particularly one involving someone you love, is something that the field of trauma psychology has spent decades trying to understand and describe. The research on witnessing trauma is distinct from the research on experiencing trauma directly, though the two overlap in important ways. What the research shows, consistently, is that witnessing a traumatic event, particularly one involving helplessness, where the witness was unable to intervene or prevent what was happening, produces its own distinct psychological aftermath. For the 6-year-old who watched Samantha disappear, this meant growing up carrying something that no 6-year-old is equipped to carry and that no adult can fully take away. She had watched. She had been unable to help. She had seen her best friend's face in a car window, and she had thought she saw the word help forming on her lips, and she had been unable to do anything about it. She was 6 years old. The guilt that child witnesses sometimes carry, the irrational but powerful sense that they should have done something, should have called out, should have run, should have found some way to stop what was happening, is one of the most insidious aspects of the psychological aftermath of witnessing trauma in childhood. It is irrational because a 6-year-old on a sidewalk cannot stop an adult man from abducting another child. There is nothing she could have done. The rational mind, even a child's rational mind, understands this at some level. But rationality and emotional experience are not the same thing, and the emotional experience of a 6-year-old who watched her best friend disappear does not operate according to the logic of what was possible and what was not. It operates according to a simpler, more painful logic: I was there. I did not stop it. She is gone. The psychological support that this child received in the aftermath of the abduction, the counseling, the family support, the careful navigation of how much she was told and when, is something we can hope was adequate to what she needed, without being able to know for certain. What we can say is that she survived it. She grew. She carried the memory without being destroyed by it. She walked into a courtroom at 9 years old and did what she needed to do. Whatever resources and support helped her get there, those resources and that support mattered. This is worth naming, in the context of a case that is often discussed primarily in terms of its forensic and legal dimensions. Behind the legal case, there was a child who needed care. And that child received enough care to be able to give what the case needed from her. The child welfare systems and the mental health professionals who supported her, whose names are not part of the public record of this case, who did their work quietly and privately in the way that such work is done, they were part of the justice that came for Samantha too. Let us spend some time on what the investigation looked like in the months after Samantha's remains were found. Because this is a part of the story that is often compressed in the retelling, the long middle, between the initial frantic search and the eventual DNA match, where the work was grueling and largely invisible and produced no dramatic breakthroughs but was nonetheless essential. Homicide investigations in working-class communities do not always receive the resources that higher-profile cases in wealthier areas receive. This is a documented reality of American policing that has been written about extensively and that represents one of the systemic inequities in how justice is administered across different communities. Stanton was not a wealthy community. Samantha Runnion was not a wealthy child. And while the case did receive significant investigative attention, particularly in the immediate aftermath and around the time of the DNA match, there were periods in between when the investigation was, by the nature of resource constraints, less active than it might have been. Samantha's mother was aware of this. She was acutely, painfully aware of this. And it was one of the things that drove her to maintain the active presence she maintained in the investigation, to call, to show up, to keep the case in the consciousness of the investigators who were working it. To be the human presence that reminded the system, consistently and persistently, that there was a family waiting. The investigators who worked this case are not villains in this story. They were professionals doing difficult work with finite resources, maintaining a case as best they could within the constraints of the system they operated in. Some of them, by all accounts, were genuinely dedicated to the Samantha Runnion case in a personal sense, the kind of dedication that goes beyond professional obligation, that comes from looking at evidence of what was done to a 5-year-old child and deciding that you are going to be the person who finds who did it. But dedication does not eliminate resource constraints. It does not create extra hours in the day or additional detectives to assign to the case. It does not speed up DNA processing at the state crime lab or expand the Cody's database faster than the database naturally grows. The investigation proceeded at the pace it could proceed. Samantha's mother made sure that pace did not slow to a stop. The specific nature of the DNA match, the mechanism by which the suspect's profile entered Cody's and was flagged against the Samantha Runnion evidence, is worth discussing in some detail, because it illustrates something important about how modern forensic investigation works and about the role that seemingly unrelated events can play in resolving major crimes. In many high-profile DNA cold case resolutions, the match comes not from the original crime but from a subsequent event. An individual who committed a serious crime years earlier is arrested for a different offense, a burglary, a drug charge, an assault, and their DNA is collected as part of that arrest. Under federal law, since the DNA Fingerprint Act of 2005, and under various state laws that preceded the federal legislation, collection of DNA from individuals arrested for or convicted of felony offenses became standard practice. The collected DNA is uploaded to Cody's, where it is automatically compared against all profiles in the system. If the person's profile matches an unsolved case, the system generates a hit. This is how many cold cases break. Not through new investigation of the original crime, but through an accidental intersection, a subsequent arrest, an uploaded profile, an automated comparison that no investigator specifically requested. The system does the work that no human investigator could do manually, comparing millions of profiles against millions of profiles, looking for the match that will unlock a case. In the Samantha Runnion case, the specific circumstances of how and when the suspect's DNA entered the system are part of the investigative record that has been discussed in various legal and journalistic accounts over the years. The key point is this: when it entered the system found the match. The 1 in 1 trillion match. The profile from 2002, waiting, with perfect machine patience, for the profile that would unlock it. That moment, the moment the hit was generated, the moment an investigator looked at a notification and saw the match, must have had a quality almost impossible to describe. 3 years of a case sitting in a database, waiting. And then the answer, arriving not with fanfare but as a line in a database report. A notification. A number followed by a name. The name of the man who had taken Samantha Runnion off a cinder block wall on the evening of July 15, 2002. The work that followed the DNA hit, the work of building the case, of identifying and interviewing the suspect, of re-engaging the child witness, of compiling the prior history, of preparing for trial, took months. This is normal. This is how serious criminal investigations work when they are done properly. Speed, at the pre-arrest and pre-prosecution stage, is not the goal. Thoroughness is the goal. Building a case that will hold up in court, that will survive the scrutiny of defense attorneys and the analytical lens of a jury, requires patience and care and attention to detail that cannot be rushed without compromising the outcome. The investigators in the Samantha Runnion case took the time required. They worked with prosecutors to ensure that every piece of evidence was properly documented and ready for presentation. They worked with forensic scientists to prepare the expert testimony that would explain the DNA evidence to a jury. They worked with child psychology experts and victim advocates to prepare the 9-year-old witness for what testifying would require of her. They notified Samantha's mother. What that conversation was like, the moment when, after 3 years of searching and calling and refusing to let the case go cold, a detective called her to say that they had a name, is something she has described in fragments over the years. The disbelief that first has to be overcome. The need to hear it said again, to make sure she has not misunderstood. The wave of emotion that is not simply relief, not simply vindication, but something more complicated, something that contains grief and anger and a specific, painful gratitude that justice might finally be coming, mixed with the knowledge that justice cannot undo what was done. She has said that she sat down. That her legs required her to sit down. That she held the phone and sat down and tried to process the fact that 3 years of searching were about to turn into something else. Something that would require a different kind of strength than the searching had required. She found that strength. She always found it. The legal proceedings in the Samantha Runnion case moved through the courts with a deliberateness appropriate to the gravity of the charges. There were preliminary hearings, in which the admissibility of various pieces of evidence was argued and determined. There were motions, on both sides, that addressed specific aspects of the prosecution's case and the defense's strategy. There was the selection of the jury, a process that in a case like this one, high media profile, emotionally charged content, a child victim and a child witness, is painstaking and lengthy, as attorneys on both sides work to identify jurors who can genuinely be fair. The trial itself lasted multiple weeks. During those weeks, the prosecution presented its case with the methodical thoroughness that the evidence warranted. They began with the timeline, the who and the where and the when of July 15, 2002. They presented the physical evidence collected at the scene where Samantha's remains were found. They called forensic scientists to testify about the DNA, its collection, its processing, the extraordinary statistical weight of the match. They called investigators to walk the jury through the 3-year timeline of the case, from the initial disappearance through the DNA hit and the identification of the suspect. And they called the child witness. The preparation for her testimony had been extensive. Child psychologists had worked with her to help her understand what the courtroom would look like, what the questions would sound like, how to handle the pressure of being in a formal legal setting with people she did not know asking her things about the worst day of her life. They had talked with her, gently and repeatedly, about what she remembered. About the importance of saying only what she actually remembered, not what she thought adults wanted to hear, not what she imagined might have happened, but precisely and only what she saw. This is the core challenge of preparing a child witness, ensuring that the preparation itself does not contaminate the testimony. That the process of helping a child get ready to testify does not inadvertently introduce information that the child then incorporates into their memory. The professionals who worked with her understood this challenge and addressed it carefully. When she took the stand, she was ready. Not ready in the sense of comfortable or at ease. The courtroom was still a formal, intimidating space, and she was still a 9-year-old being asked to do something that would challenge most adults. But ready in the sense of clear. Clear about what she remembered. Clear about what she was going to say. Clear about the stuffed animal in her arms and the finger she was going to raise and the face she was going to point at. She had been carrying this for 3 years. She had carried it through 2nd grade and 3rd grade and into 4th. She had carried it in the ordinary moments of childhood, at recess, at birthday parties, at sleepovers where she might have been expected to just be a kid. She had carried it home every evening to a family that loved her and tried to support her and probably did not always know how to talk about what she had seen without making things worse. She had carried it alone, in the particular way that children carry things that no one around them fully understands. And then she walked into that courtroom and she set it down. She said what she knew. She pointed at the man she had been seeing in her memory for 3 years. And then she was done carrying it alone. Because from that moment forward, it belonged to the court. To the jury. To the official record of what had happened. It was no longer only inside her. It was on the record. It was shared. It had done the work that it was carried all that time to do. The cross-examination of a child witness in a murder trial is one of the most ethically complex exercises in criminal law. Defense attorneys are obligated to challenge the testimony. That is not optional, it is required by the nature of their representation. But challenging the testimony of a 9-year-old who is describing the abduction of her murdered best friend requires a calibration that goes beyond ordinary cross-examination strategy. Defense attorneys in these situations typically focus on process rather than on the child directly. They challenge not, "You're lying," but, "The conditions under which you were interviewed may have introduced information into your memory." They challenge not, "You didn't see what you think you saw," but, "The 3-year gap between the event and the formal identification is significant enough to raise questions about the reliability of the identification." These are legitimate challenges. They are the challenges the law requires to be made. And they were made, in the Samantha Runnion trial, with the skill and care that competent defense counsel brings to this kind of case. But they did not break the testimony. The child had been interviewed with appropriate protocols. The lineup had been constructed correctly. The identification had been made without contamination. The 3-year gap was real and was acknowledged, but the research on the durability of central detail memories of traumatic events, memories like the face of the man who took your best friend, supported the prosecution's position that the identification was reliable. The cross-examination ended. The witness stepped down. She had held. The jury's deliberations lasted several days. This is, for the families involved in a trial, one of the most agonizing periods imaginable. The evidence has been presented. The arguments have been made. And now 12 people who were strangers to the case at the start of the trial are sitting behind a closed door making a decision that will define what justice looks like for your family. During those days, Samantha's mother has described maintaining a kind of forced routine. Showing up at the courthouse. Waiting. Going home. Trying to sleep. Returning. Waiting. She brought photographs of Samantha to the courthouse. This is something that victims' families sometimes do, carry the physical presence of their lost child into the legal proceedings, in the form of photographs or small keepsakes. It is a way of insisting, in a process that is necessarily abstract and procedural, on the humanity at its center. Of saying, do not forget that there was a real child. Do not let the testimony and the exhibits and the legal arguments crowd out the specific, irreducible fact that this was a real girl with a gap-toothed smile who loved purple. She brought Samantha into the courthouse in the only form available to her. And she waited. The verdict arrived on a weekday afternoon. The notification came through the courthouse's standard procedures, a message that the jury had reached a verdict, that everyone was to return to the courtroom. Guilty. On all counts. The people in the courtroom who were there in support of Samantha's family reacted in the ways that people react to verdicts in cases like this, with tears, with held breath released, with the particular kind of sound that is not quite crying and not quite relief and is only really describable as the sound of something enormous being felt. Samantha's mother did not make any sound, according to accounts from people who were there. She held the photograph of her daughter. She closed her eyes. And then she opened them, and she was still in the courtroom, and Samantha was still gone, and justice had been done, and none of those things contradicted each other. All of them were true simultaneously. This is what justice feels like when grief is involved, incomplete and necessary. A thing that had to happen. A thing that had to be fought for. A thing that was right and real and that changed nothing about the fundamental fact of a child taken from a cinder block wall on a summer evening. She held the photograph. She let the verdict settle around her like something that had taken 3 years to arrive. The sentencing hearing came weeks later. Both sides had the opportunity to present arguments about the appropriate sentence, the prosecution arguing for the maximum available under the law, the defense seeking mitigations, victims' family members and impact witnesses given the opportunity to speak. Samantha's mother spoke. She stood at the lectern in the courtroom and she looked at the man who had been convicted of murdering her daughter. And she spoke about Samantha. About the gap-toothed smile. About the color purple. About the best friend 3 houses down. About the cinder block wall and the summer evening and the 5 years of life that was all Samantha got. She spoke about what it was like to receive the phone call. To be told that her daughter had been taken. To spend 3 years searching and advocating and refusing to accept that justice would not come. She spoke about what those 3 years had done to her health, to her relationships, to her ability to imagine a future that was not organized entirely around the question of who had killed her child. She spoke, finally, about what she intended to do going forward. About the legislation she was going to continue to advocate for. About the families she was going to continue to support. About the ways in which she intended to turn the worst experience of her life into something that would have meaning beyond its own horror. She spoke for Samantha. And the judge, when he delivered the sentence, acknowledged what she had said. Acknowledged the loss. Acknowledged the years. Acknowledged the inadequacy of any sentence to address what had been taken. And then he delivered the sentence. And it was done. Or as done as something like this ever gets. In the years since the Samantha Runnion case concluded, the world has changed in ways that are both hopeful and discouraging in the specific context of child safety. On the hopeful side, CODIS has grown enormously. The DNA database that existed in 2002, which did not contain the suspect's profile, is vastly larger and more comprehensive today. The probability that a violent offender with any prior criminal record who offends today will have their DNA in a searchable database is considerably higher than it was in 2002. Cold cases are being resolved today, regularly, consistently, through DNA matches that would not have been possible with the technology and database coverage of 20 years ago. The techniques for interviewing child witnesses have improved. The protocols are better. The training for forensic interviewers is more rigorous and more widely implemented. The understanding of how to prepare child witnesses for the courtroom experience is more sophisticated. The legal framework for accommodating child witnesses, special measures that courts can use to reduce the stress of testimony without compromising its integrity, is more developed. The legislative landscape for child protection has expanded and strengthened. Not uniformly, there are still gaps, still jurisdictional disparities, still cases that fall through cracks that should have been closed years ago. But the overall trajectory has been toward more rigorous monitoring and management of individuals with histories relevant to child safety. The work that Samantha's mother contributed to has continued, building on the foundation that her case helped lay. On the discouraging side, children are still taken. Still harmed. Still murdered. The problem has not been solved. It cannot be solved in any absolute sense, because the human capacity for violence against children is not a policy problem with a policy solution. It is a dark fact of human nature that can be managed and reduced but not eliminated. The goal, the only realistic goal, is reduction. Fewer children harmed. Fewer cases that follow the tragic pattern of the Samantha Runnion case. Fewer mothers who have to make the phone call that Samantha's mother made and ask themselves, years later, whether better systems might have prevented what happened to their child. That goal is being pursued. It is being pursued by researchers and legislators and law enforcement professionals and advocates and, yes, by content creators who believe that keeping these stories in the public consciousness is part of the work. At Coldcase Crimelab, we believe that. We believe that every time we tell a story like Samantha's, every time we give a case the depth and the attention and the human dimension that it deserves, we are contributing, in our own small way, to that ongoing work of reduction. Of making the world, one story at a time, a slightly more honest place about the dangers that children face and the systems that either protect them or fail them. There is one more thing we want to say about this case before we close. About the specific moment that has, more than any other moment in the legal proceedings, defined how the Samantha Runnion case is remembered and discussed. The moment when a 9-year-old girl raised her arm in a California courtroom and pointed across the room. He throwed her into the car. When she was in the car, she just looked at me. I think she said, "Help." Or something. The grammatical imperfection of those words, "he throwed her," is part of why they have lasted. Why they appear in legal textbooks and advocacy documents and news reports and in this script tonight. Because the imperfection is the authenticity. Because a 9-year-old who says, "he throwed her," is not performing testimony. She is not reciting a prepared statement. She is saying, in the only language available to her at 9 years old, the precise and specific thing that she saw. Threw is the grammatically correct past tense of throw. But throwed is what a 9-year-old says when she is not thinking about grammar. When she is thinking about what she saw. When she is back on that cinder block wall on the evening of July the 15th, 2002, and she is watching a man grab her best friend and put her in a car and drive away. He throwed her into the car. That is the sound of a child telling the truth. Unpolished. Uncurated. Direct. That is the sound of justice, too. Because justice, when it finally arrives, often sounds like this, imperfect, human, particular, and true. The story of Samantha Runnion is also, in ways worth examining explicitly, a story about what happens when we underestimate children. Adults have a long history of underestimating children, their intelligence, their capacity for understanding, their emotional depth, their ability to process and carry and accurately report significant experiences. The history of child witness law in America reflects this, the presumption, held for much of legal history, that children were inherently unreliable witnesses, that their memories were too malleable, their language too imprecise, their developmental stage too removed from adult rational consciousness to produce testimony that courts could trust. This presumption was not entirely wrong. Children are more susceptible to certain types of suggestion than adults. Their memory for peripheral details is less reliable than adults. Their understanding of the formal context of a legal proceeding, of what it means to take an oath, of the consequences of inaccuracy, of the distinction between what they observed and what they inferred, is limited by their developmental stage. But the presumption was wrong in the ways that mattered most. Because children, particularly children reporting on significant, emotionally salient events that engaged their full attention, can be accurate witnesses. Their core memories of central details can be extraordinarily durable. And their testimony, when properly elicited, can be the most powerful tool in a prosecutor's case precisely because of the qualities that used to make courts doubt them, their directness, their unvarnished specificity, their complete inability to perform a sophisticated deception. A child who says, "he throwed her into the car," is not lying. A child who is lying uses adult-sounding language, carefully constructed sequences, an account that avoids specificity and relies on vague generalities. A child who is telling the truth says, "he throwed her," and means exactly that. The Samantha Runnion case demonstrated what child witness testimony, properly handled, can do. It has been cited specifically in the academic literature on child witnesses as a case that represents best practices, in how the witness was supported, in how her testimony was elicited, in how it was presented to the jury, in how it was protected from cross-examination challenges that would have corrupted rather than tested it. That citation, in academic literature, in legal training programs, in the curriculum of forensic interviewers and child victim advocates, is another of the case's legacies. An institutional legacy. A contribution to the practice of the law that will outlast the specific facts of the case itself and continue to influence how other cases, involving other children, are handled. The families of murder victims carry their grief in different ways, and over different timescales, and with different resources and different support systems. There is no single experience of being a surviving family member of a homicide victim. There is no roadmap. There is no predictable trajectory from the moment of loss to something that resembles equilibrium. Samantha's mother has described her experience in terms of phases. The initial shock, a period of days in which the news that Samantha was missing and then gone was so catastrophic that the mind could only process it in fragments. Then the searching phase, driven by grief but also by the human need to do something, to be active, to not simply sit in the horror of what had happened. Then the legal phase, the period leading up to and through the trial, which required a different kind of strength than searching had required, a more formal and structured engagement with the institutions of justice. And then what comes after the verdict? Which is, by her account, the hardest phase in some ways. Because the verdict removes the forward momentum, the constant purpose of the search, the specific goal of the legal proceedings, and replaces it with a stillness. An after. A world in which the case is resolved and Samantha is still not coming back. The advocacy work she moved into after the verdict was, among other things, a way of managing that stillness. Of finding a forward momentum that was consonant with the magnitude of her grief. Of doing something with the knowledge and the experience and the connections she had accumulated over years of searching, rather than letting them dissolve into the ordinary grief of a parent who has lost a child and has no channel left for the energy of that grief. This is not to diminish the advocacy. The advocacy has been genuine and consequential and has produced real results in the world. But it is to say that the advocacy, like most human behavior, serves more than one purpose at once. It serves the public purpose, the reform of systems, the protection of future children. And it serves the private purpose, the need to convert grief into something that has forward momentum, that faces the future rather than only the past. Both purposes are valid. Both are human. Both are part of how a mother honors a murdered daughter and keeps herself in the world at the same time. The legal representation of the defendant in the Samantha Runnion case, the defense attorneys who argued on his behalf, has been discussed in various accounts as competent and thorough. This is worth acknowledging explicitly, even in the context of a story about the justice that was ultimately done for Samantha. Because the integrity of the verdict depends, in part, on the quality of the defense. A guilty verdict that is not tested by competent defense counsel is not the same as a guilty verdict that has survived rigorous challenge. The defense in this case did what defense counsel should do. They challenged the evidence. They raised legitimate questions. They cross-examined witnesses appropriately. They did not protect their client from justice. No defense attorney can do that when the evidence is what the evidence was in this case, but they ensured that the justice that came was real. That it was not a conviction by default, not a verdict reached without scrutiny, but a finding that had passed the test of genuine adversarial challenge. That matters. It matters for the integrity of the verdict. It matters for the integrity of the legal system. And it matters, in a specific and important way, for the experience of Samantha's family. Because a guilty verdict that has survived a rigorous defense is a verdict that cannot easily be questioned, cannot be appealed on grounds of inadequate defense, cannot be undermined by the argument that the defendant did not have a fair trial. Samantha's mother needed that. She needed a verdict that was solid. That would stand. That could not be taken away. The defense gave her that, through the quality of their representation. This is one of the paradoxes of the adversarial legal system. The best outcome for the victim's family is sometimes served by the quality of the defense. The physical evidence in the Samantha Runnion case, beyond the DNA, has been discussed in various accounts in terms that are sensitive to the family's ongoing pain. We are going to be similarly sensitive here, and not dwell on details that serve no purpose beyond their shock value and that would require revisiting aspects of what was done to Samantha in ways that are not necessary for the purpose of understanding the case and its significance. What can be said is that the physical evidence was collected with care, was maintained with integrity, and supported the prosecution's case in ways that went beyond the DNA alone. The convergence of physical evidence types, the combination of forensic biology, trace evidence, and the spatial analysis of where evidence was found and what it indicated, built a picture that was consistent with the narrative the prosecution presented and inconsistent with any innocent explanation. The forensic work in this case, start to finish, represents the kind of thorough and meticulous evidence collection and processing that cold case resolutions depend on. The evidence had to be maintained for 3 years without degradation. It had to be properly documented from the moment of collection so that its chain of custody was unassailable. It had to be processed with enough precision that the DNA profile was of sufficient quality to make the 1 in 1 trillion determination. These things happened. The work was done correctly. And 3 years after a summer evening in Stanton, the physical evidence that had been waiting in an evidence room and in a database was ready to support the justice that finally came. One of the questions that people ask, when they engage with cases like the Samantha Runnion case, is, why does it take so long? The question is understandable. From the perspective of a grieving family, from the perspective of a community that has experienced the trauma of a violent crime and wants resolution, the years of waiting, for a DNA match, for a named suspect, for a trial, for a verdict, feel unconscionable. Why should it take 3 years? Why should a family have to wait that long for justice? The answer is complicated. It involves the mechanics of DNA databases and their growth over time. It involves the resource constraints of crime labs, which have historically been underfunded and overwhelmed and which have produced, in jurisdictions across the country, backlogs of unprocessed DNA evidence that represent thousands of unsolved cases waiting for matches. It involves the time required to build a solid legal case once a suspect has been identified. It involves the procedural requirements of the court system, which are designed to ensure fairness rather than speed. These are not satisfying explanations, from the perspective of a family. But they are real ones. And they point to specific, addressable failures that advocates have worked to correct: increased funding for crime labs, mandatory processing timelines for DNA evidence, expanded CODIS uploads, faster integration of state and federal databases. Progress has been made on all of these fronts. DNA evidence is processed faster today than it was in 2002. The database is more comprehensive. The gap between evidence collection and resolution, in cases where DNA evidence exists, has shortened. Not enough. Not close to enough. The backlog of unprocessed DNA evidence in American crime labs remains a scandal. The families waiting for resolution of cases that involve biological evidence that has never been tested remain a population that the justice system has, in a very real sense, abandoned. But the direction is right. The work is being done. And cases like Samantha's, which demonstrated both what DNA evidence can accomplish and how much faster it could have accomplished it with better resources, have contributed to the arguments for that work. We want to close tonight with something that is not a fact about the case or an analysis of the evidence or a discussion of the legislative legacy. We want to close with something simpler. We want to close with the image of a 5-year-old girl on a summer evening. She is sitting on a cinder block wall. The heat of the day is starting, just barely, to release its grip on the neighborhood. The air smells like warm asphalt and distant barbecue and the particular Southern California summer smell that people who grew up there carry with them everywhere they go. The light is long and golden the way July light is in the late afternoon. Her best friend is next to her. She is 5 years old. She has been alive for 5 years and she has spent most of that time doing what 5-year-olds do, learning the world. Learning that the color purple is her favorite color. Learning that her best friend is someone she wants to spend every available moment with. Learning that summer evenings on cinder block walls are one of the good things, one of the simple and abundant good things that life keeps providing. She does not know what is about to happen. She is just 5 years old, on a summer evening, with her best friend beside her. She deserved to grow up. She deserved everything that a life contains, the hard things and the easy things, the boring things and the extraordinary things, the ordinary Tuesday afternoons and the moments that feel like the whole world is brighter than it was before. She deserved all of it. She was Samantha Runnion. And we say her name. This is Coldcase Crimelab. We will be back with another case soon. Until then, hold your people close. Advocate for the systems that protect children. Support the families who are still waiting. And remember, cold cases don't close themselves. Someone has to keep asking. We will keep asking. For Samantha. For all of them. Good night. If tonight's episode moved you, if the story of Samantha Runnion and her mother's fight for justice is something you want to support, please like this video right now and subscribe to Coldcase Crimelab. Leave a comment below, tell us what you will take from tonight, tell us how this case made you feel, or simply write Samantha's name so that this community can say it together. Every like, every comment, every subscription tells us that this work matters. That the stories we tell here deserve to be heard. That the victims we speak for deserve to be remembered. Hit that subscribe button. Turn on those notifications. And bring someone you trust to the next episode, because the cases we cover at Coldcase Crimelab are cases that everyone should know. Thank you for being here. Thank you for watching. Thank you for caring. Good night. Coldcase Crimelab, because cold cases don't close themselves. Let us return one more time to the question at the center of this story, the question that Samantha's case forces us to sit with, not just as a matter of historical fact but as a living, ongoing question that the justice system and the child protection community have not yet fully answered. What do we owe to children we cannot protect in the moment? This is a different question from the question of what we owe to children in the abstract, the general obligation to create and maintain systems of protection, to pass and enforce laws that recognize children's vulnerability and respond to it. That obligation is real and important and is the subject of ongoing policy debates that matter enormously. But the more specific question, what do we owe to the children who were harmed before the systems were good enough to protect them, who fell through the gaps, who became the evidence that the gaps existed, that question has a different quality. A more personal quality. It is the question that Samantha's mother asked implicitly and explicitly in every legislative hearing she attended, in every interview she gave, in every phone call she made to investigators during the 3 years between Samantha's death and the trial. What do you owe my daughter? What did you owe her before it was too late? The answer that the system gave, eventually, imperfectly, but genuinely, was a conviction. A sentence. A set of legislative reforms that made it harder for the pattern that had produced Samantha's murder to produce another one. A set of improvements to the forensic and investigative and legal tools that handle these cases. These are real answers. They are not the answer a mother wants when she asks what you owe her daughter. But they are real answers. They are the answers the system is capable of giving. And given what the system is and what it can do, they are not nothing. They are not enough. They never will be enough. But they are not nothing. The child witness in the Samantha Runnion case, the woman she has grown into since the summer of 2002, has, by various accounts, built a life. This is said carefully, because we do not want to imply that building a life after witnessing something like that is simple, or that the passage of time resolves what she experienced into something manageable without cost or effort or ongoing struggle. Building a life after carrying something like this requires work that most people never have to do. But she has done it. She was 6 years old on a cinder block wall. She was 9 years old in a courtroom. She is an adult now, and she has lived those years in between and beyond with whatever she carried from that summer evening. She has found ways to inhabit the world that a traumatic childhood memory and a court appearance and the weight of having been the witness to her best friend's murder would allow her to inhabit. We speak of her with care and with gratitude that she has never been asked to make public. She did not ask to be a witness. She did not volunteer for the role that history assigned her on the evening of July 15, 2002. She was simply there. A 6-year-old in the wrong place at the right time, or the right place, depending on how you look at it. The only person in a position to see what she saw and remember what she remembered and eventually say what she said. She carried it. She said it. And then she went on. We hope the going on has been as good as it could be. There is a concept in trauma research called post-traumatic growth. It describes the phenomenon, documented in individuals across cultures and across different types of traumatic experience, whereby people who have experienced significant trauma not only recover but, in certain measurable dimensions, grow beyond their pre-trauma baseline. They develop greater appreciation for life. They develop stronger relationships. They develop a more nuanced understanding of human possibility, both the terrible and the extraordinary. They develop what researchers sometimes call a sense of new possibilities, a recognition that if they can survive what they survived, they may be capable of things they would not previously have imagined themselves capable of. Post-traumatic growth does not erase the trauma. It does not make the trauma worth having. It does not mean that the person who experienced it would choose to have experienced it if given the choice. It simply describes what research has found, that some people, in the aftermath of terrible events, find within themselves capacities that the ordinary course of an untouched life might not have called forth. Samantha's mother is, by any fair assessment, a case study in post-traumatic growth. The woman who emerged from the experience of losing Samantha, from the investigation, from the advocacy, from the trial, from the legislative work, is a different person than the woman who sat on that cinder block wall and talked to her daughter on summer evenings in 2002. Not a better person in any sense that diminishes what was taken from her. But a person who has found, in the worst experience of her life, capacities for advocacy and persistence and public presence and legislative engagement that she might never have known she had. She did not become an advocate because she wanted to. She became an advocate because it was the only forward she could find. Because the alternative, the stillness of a grief with no channel, no purpose, no forward momentum, was not something she could survive. She found the only forward available. And the forward she found has made the world, in specific and measurable ways, better for children who will never know her daughter's name. Forensic science is, in many ways, the hero of the Samantha Runnion story. Not the only hero, the child witness, the mother, the dedicated investigators, the prosecutors, all played essential roles. But the forensic science is the element that transformed the case from a tragedy without resolution to a tragedy with justice. Without the DNA profile. Without the Cody's match. Without the extraordinary 1 in 1 trillion probability that made the forensic case essentially undeniable, the child witness's testimony, powerful and important as it was, might not have been sufficient to produce a conviction. The combination was what the prosecution needed. The science and the human witness together. The cold precision of a laboratory analysis and the warm imprecision of a 9-year-old saying, "He throwed her." The 1,000,000,000,000 statistical certainty and the specific, personal, eyewitness memory of a child who had been there. Neither alone was enough. Together, they were overwhelming. This is how serious criminal cases often work. A single pillar of evidence, however strong, can be attacked. But multiple pillars of different types, all pointing in the same direction, create a structure that is very difficult to bring down. The Samantha Runnion prosecution understood this and built accordingly. The result was a case that the defense could challenge, and did challenge, professionally and thoroughly, without being able to break. Let us spend a moment on the investigators specifically. The detectives who worked the Samantha Runnion case over the 3 years between the initial disappearance and the arrest were not public figures. They did their work largely out of the spotlight, in the ordinary conditions of police investigation, long hours, limited resources, the constant pressure of other cases demanding attention while trying to maintain the thread of this one. Their names are not widely known. They did not write memoirs about the case or go on speaking tours. They did their jobs, and their jobs were the unglamorous, essential, daily work of maintaining a case that could not afford to be forgotten. Some of them have spoken, in general terms, about what the case meant to them professionally and personally. About what it is like to carry an unsolved child murder for 3 years, to look at the photographs of Samantha that were part of the case file, to know that her mother was calling regularly to check on progress, to feel the weight of a case that had answers somewhere in the forensic and investigative record but that the database had not yet unlocked. They described the moment of the DNA hit with a mixture of professional satisfaction and something more personal. The knowledge that the waiting was over. That the profile that had been sitting in the database since 2002 had finally found its match. That the case that had been kept alive through years of persistence, theirs, the mothers, the prosecutors, the victim advocates, was about to become something. They had been the keepers of the thread. They had not let it break. And when the thread connected to its other end, it connected because they had kept it. The Samantha Runnion case and the legislative reforms it helped inspire have been studied by researchers at universities and policy institutes who work on child protection issues. Papers have been written. Conference presentations have been given. The case appears in the literature as an example of how individual cases can drive systemic change, of how the specific, terrible, human details of a single case can penetrate political and bureaucratic systems in ways that abstract statistical arguments cannot. This is one of the arguments for telling these stories publicly. For giving individual cases the depth and the attention that they deserve. For not letting them collapse into statistics. Statistics about child abduction and murder are available. They are published annually by federal agencies and by research organizations and by advocacy groups. They are important. They shape policy debates and funding allocations and legislative priorities. But statistics do not change the way that a single story changes things. A story about a specific 5-year-old who loved purple, whose best friend never forgot her face, whose mother never stopped fighting, that story moves through the world differently than statistics. It creates a kind of understanding that is more visceral and more durable than the understanding that statistics create. It makes the abstract concrete. It makes the impersonal personal. It gives a face and a name and a gap-toothed smile to numbers that would otherwise remain numbers. This is what Samantha's mother understood when she chose to advocate publicly. When she chose to testify before legislative committees and give interviews and maintain the public profile of her daughter's case long after the verdict. She understood that Samantha's story, the specific, particular, human story of a 5-year-old on a cinder block wall, was a resource. A resource that could do things that data alone could not do. She used that resource deliberately and wisely. She gave her daughter's story the work of doing good in the world. We want to talk, briefly, about the experience of producing this episode. About what it means to sit with a story like this one and decide how to tell it. What responsibilities come with that decision. What we owe to the victim, to the family, to the witness, to the community. At Coldcase Crimelab, these questions are not hypothetical. They are part of every episode we make. We talk about them before we start writing. We talk about them as we research. We talk about them when we sit down to record. The decision to tell a story like Samantha's, to give it the depth and the time and the attention that tonight's episode represents, comes with specific obligations. The obligation to be accurate. To get the facts right, to the best of our ability, and to be clear about the limits of what we know and what we are inferring. The obligation to be respectful, to the victim, to the family, to the witnesses, to the investigators. Not to sensationalize. Not to use the details of the crime as entertainment in a way that reduces a real person's murder to spectacle. These are not always easy obligations to fulfill. The line between compelling storytelling and exploitation is a real line, and it requires constant attention to stay on the right side of it. We try. We do not always succeed perfectly. But we try, every episode, to tell these stories in a way that honors the people at their center. Samantha deserves to be honored. Her mother deserves to be honored. The 9-year-old in the courtroom deserves to be honored. We hope tonight's episode has done that. The question of what it means to close a case, in the legal sense, in the investigative sense, in the human sense, is one that every episode we make at Coldcase Crimelab circles around. Because cases close differently in different senses, and the closure that comes in one sense does not always produce the closure that families and communities hope for in other senses. In the legal sense, the Samantha Runnion case is closed. A defendant was tried. A verdict was reached. A sentence was delivered. The case has passed through the appellate process in whatever form that took. It is, in the formal language of the law, resolved. In the investigative sense, the case is closed. There is a named perpetrator. The question of who murdered Samantha Runnion has an answer that is part of the permanent record. In the forensic sense, the evidence has served its purpose. The DNA profile that waited in the database for 3 years found its match and helped convict the person it pointed to. The forensic work is done. But in the human sense, in the sense that matters most to the people who lived this case, nothing is ever quite closed. A mother who lost her daughter at 5 years old does not experience closure. She experiences the slow, difficult, ongoing work of finding ways to live with what cannot be undone. Of directing grief into advocacy. Of finding meaning where meaning feels inadequate to the magnitude of the loss. A child who witnessed her best friend's abduction does not experience closure. She experiences, over the years, the gradual integration of what she saw into the ongoing narrative of her life, an integration that may be more or less successful at different points, that may require ongoing support and processing, but that is never complete in the way that the word closed implies. These human realities sit underneath the formal closure of the legal case. They are not captured by verdicts or sentences or legislative reforms. They are carried by individuals, privately, for the rest of their lives. We name them here because they deserve to be named. Because the story of what happens to survivors after a case is closed is part of the full story of the case. Because the human cost of violent crime against children is not fully accounted for in the legal resolution, no matter how just that resolution is. It is carried in people. It is carried by Samantha's mother, who keeps saying her daughter's name. By the witness, who never forgot his face. By the investigators who kept the thread intact for 3 years. By the community of Stanton, which changed in ways visible and invisible after the summer of 2002. All of them carry it. And when we tell this story, we carry it with them. That is what it means to tell a story like this one. That is what it means to say a name. Samantha Runnion. 5 years old. Stanton, California. July the 15th, 2002. She loved purple. She had a best friend. She had a mother who loved her more than anything in the world and who never stopped fighting for her. She deserved to grow up. We say her name tonight, and we will say it again, and we ask you, everyone in the Coldcase Crimelab community, to say it with us. Samantha. She was here. She mattered. She still does. This has been Coldcase Crimelab. Thank you for being here. Thank you for watching. Thank you for caring about the stories that deserve to be told. If tonight meant something to you, if Samantha's story is something you will carry forward, please leave a like on this video, subscribe to the channel, and leave a comment below with her name or with whatever this episode brought up for you. We read every comment. We hear every one of you. And your engagement, your presence in this community, is what allows us to keep doing this work. Hit that like button. Subscribe. Leave a comment. And bring someone with you to the next episode. We will be back soon. Until then, be safe, be watchful, and never stop asking the questions that need to be asked. Cold cases don't close themselves. Good night. Coldcase Crimelab, because cold cases don't close themselves. There is something we have not yet said directly about the role that online communities and digital media have played in cases like the Samantha Runnion case in the years since its resolution. And it is something worth saying, because it connects to why we are here tonight, why a channel called Coldcase Crimelab exists, and what function it serves in the broader ecosystem of public awareness about violent crime and the systems designed to address it. The conversation about cold cases and unsolved crimes did not always have a public home. For much of the history of criminal investigation, these stories lived in the files of police departments and prosecutors' offices, in the memories of victims' families, in the occasionally revisited newspaper archives of local papers. They were not, in any meaningful sense, part of a public conversation. They were private tragedies, attended to by professionals and suffered by families, invisible to the broader public except in the immediate aftermath of the crime. The internet changed that. Digital media changed that. And true crime content, podcasts, YouTube channels, documentary films, written investigations, has created something genuinely new, a public community of people who care about these cases, who follow them, who research them, who keep them in the collective consciousness in ways that were impossible before the internet made that kind of distributed attention possible. This community has had real effects on real cases. Tip lines have received information from people who heard about a case on a podcast. Cold cases have been reopened in response to renewed public attention generated by a documentary or a YouTube series. Families of victims have found, in these communities, a form of support and collective recognition that they could not find anywhere else. The Samantha Runnion case was resolved before this community really existed in its current form. But it exists as part of this community's consciousness now. It is taught, cited, discussed, and revisited. And that continued attention, the fact that Samantha's case is still being told, still being examined, still being used to understand the principles that matter for child safety and forensic investigation and the treatment of child witnesses, is itself a form of ongoing advocacy. When we tell Samantha's story here on Coldcase Crimelab, we are participating in that community. We are contributing to the collective project of keeping these cases in the light, of making sure that the lessons they teach are heard by the people who need to hear them, of ensuring that the victims whose cases we discuss are remembered by more than just their families. This is why we do this. Not for entertainment, though we hope these episodes are engaging and worth your time. Not for any single commercial purpose. But because we genuinely believe that public knowledge of these cases matters. That public understanding of how the justice system works and fails and sometimes, finally, gets it right matters. That saying the names of children like Samantha, in public, repeatedly, so that they are not forgotten, matters. It matters. We believe that. And the community that has gathered around this channel, the people who subscribe and watch and comment and share and bring these stories to people they know, are part of that belief. Part of that project. Part of the ongoing work of keeping these names in the light. Thank you for being part of it. Before tonight's episode truly closes, we want to address something that comes up often in the comments of episodes like this one, something that reflects the genuine ethical engagement of our community with the stories we tell. People ask, is it appropriate to tell these stories this way? To take a real crime, a real family, a real victim, and construct from it a narrative that is designed to be compelling, to be watchable, to hold an audience's attention for the length of an episode? It is a fair question. It deserves a real answer. We believe the answer is yes, conditional on doing it with appropriate care and purpose. The telling of these stories is not inherently exploitative. It becomes exploitative when it prioritizes shock and sensation over truth and meaning. When it lingers on violent details for their emotional impact rather than their explanatory relevance. When it treats the people involved, the victims, the families, the communities, as characters in a story rather than as human beings who are still living with these events. We try, in every episode, not to do those things. We try to tell stories with the depth and the accuracy and the respect that the people in them deserve. We try to use the platform that this community has given us to advance genuine understanding of the cases we cover, of the systems they illuminate, of the lessons they teach. We try to honor the victims by saying their names and telling their stories in ways that make clear why those stories matter beyond their immediate horror. In the case of Samantha Runnion, we believe this episode has done that. We believe it has treated a 5-year-old girl and her mother and the witness who never forgot with the respect they deserve. We believe it has used the forensic and legal details of the case in service of genuine understanding rather than mere sensation. We may not have gotten everything exactly right. We may have made judgments about what to include and what to leave out that others would have made differently. True crime content is always an exercise in judgment, and judgment is always imperfect. But the intention, to honor Samantha, to educate our community, to contribute to the ongoing work of child safety and justice, that intention is genuine. We hold that intention every time we sit down to make an episode. We hold it tonight. The final image we want to leave you with tonight is not from the courtroom. It is not from the forensic laboratory. It is not from the legislative hearings or the news conferences or the years of advocacy. It is from the street. From the cinder block wall. From the summer evening before anything happened. 2 girls. Best friends. Sitting in the July heat that was just barely starting to lift. Talking about whatever 5-year-olds and 6-year-olds talk about when they are together on a summer evening in a neighborhood that feels safe. Maybe arguing. Probably laughing. Certainly together in the easy, uncomplicated way that childhood friendships have, the way that asks nothing and offers everything and feels, while it is happening, like the most natural thing in the world. That was real. That happened. Before everything that happened after, there was that. 2 children, friends, a summer evening, a cinder block wall. That is what was there before it was taken. That is what Samantha Runnion deserved more of. More summer evenings. More best friends. More easy, uncomplicated, ordinary moments of being alive and being young and being loved. She deserved all of it. She got 5 years. We say her name so she is not forgotten. We tell her story so it means something. We ask you to carry it with you, not as a burden, not as a source of fear, but as a reminder of what is at stake when we talk about child safety systems and forensic databases and legislative reforms. A reminder that underneath all of those abstract policy conversations is a very concrete, very specific, very human reality, a 5-year-old girl who loved purple and had a best friend and sat on a cinder block wall on a summer evening and deserved to grow up. Her name was Samantha Runnion. Say it. Remember it. And keep watching Coldcase Crimelab, because there are more names. More cases. More stories that deserve to be told and victims who deserve to be remembered. We will be here. Good night. Coldcase Crimelab, because cold cases don't close themselves.